So over the past, I would say 8 to 9 years, the county judge's office has been reviewing and has reviewed our current zoning and planning ordinances. And gosh, I don't know, it's been over a year now, maybe 2. We put forth a plan into the quorum court to change some of that up. And the real change was the change as it relates to zoning. The quorum court has removed that change. So we won't be talking about a change in zoning because that's not what's before us anymore. But we're here on a public hearing again on a change. And so I'm going to go through this line by line so we can answer any questions that anybody may have. And I'll start with let me start with this. State law requires that counties codify their ordinances at least every 5 years. And so for I don't know how many years, it's got to be 20 plus years prior to me coming to the county about 9 years ago, Washington County utilized the services of a company called Municode. Municode exists solely to codify municipal, county, and parish codes around the country, and that's what they do. And so for a number of years, for a very long time, that's what the county utilized. That's what everybody pretty much utilized. Within the last few years, the Arkansas Association of Counties started offering codification services to its members, of which Washington County is a member. It saves the county money. It's free because we're a member, whereas we're paying several $1,000s a year to have our ordinances codified with Municode. Interestingly enough, the online codification is actually housed with Municode still, but the codification part comes from the Association of Counties. And so we switched over to that. The quorum court passed an ordinance making that change. The book that we used to have, you can go up to the county clerk's office, it's blue. This is the new one, it's green, it's from the Association of Counties. The problem is, if you go to look and want to read through the urban and rural development portion of that, it's very small. As you can see, this is it. There's a reason for that. The quorum court had gotten in the habit of amending the codified code when it was changing what it was doing. Arkansas law is very clear that only an ordinance can change an ordinance, and if you're going to change something, you have to change the ordinance. The codified code's there just to help people. Currently, our planning code, these are, and this is front and back, this is every ordinance we have on the books for planning and zoning, and it goes back to the 70s, okay? And so instead of people having to thumb through this and try to figure out if somewhere later down the line there was an amendment or if it was changed, we direct them to the codified code. As it stands now in our new codified code, the zoning and planning, this portion of it's not in there. There's a list of about 105, that's how many there are, 105 ordinances with hyperlinks so people can go look at those ordinances and try to figure it out from there. Because of that, we recognize the need to rewrite, not exactly as the old codified code was written, but in a way that would allow the Association of Counties to come in and codify this code in our new system. And so to do so, planning and I got together and we utilized the previous codified code. This is a copy of what that used to look like. It used to be chapter 11. In the new section, it is chapter 13. The numbering system starts at 1300, whereas this is 11. You can see. So naturally, there were a lot of cross references in here that had to be changed. I'll go over a lot of that. But this was kind of what we were looking at, just the table of contents. And so the first thing after the table of contents that we get to here are the definitions. And so we started ours exactly the same. What you'll see is this that you have right here is exactly in the same order that what we are proposing to be passed by the quorum court. And essentially, with very few exceptions, essentially it's the exact same thing that we have. And I'll point out every single change and difference, and Sam and I can explain what that's for. So we started with definitions. The issue is there are definitions all throughout the old code. So Sam took it upon himself to take and put all those definitions in one spot instead of having multiple areas that had definitions. And so the ones that are highlighted in yellow are the definitions that we've moved from the old parts of the code up to the definitions section. So you can see accessory buildings and uses, adjacent, administrative officer, agricultural uses. I won't go through all of them, but you can see there are a lot of definitions that have been moved up. A lot of things that we try to make sure we clarify really well. And that's the first portion. Now there's a lot of it that is the same. As you can see, 26 county engineer, county plan, county planning board. The ones that were in there are still in there. We just added a bunch that were kind of spread out throughout the plan. And so we actually even added a notification area as a definition so that people could better understand what that notification, we get a lot of questions about the notification because as the code that's been written and passed, there are two different notification areas depending on the project. A conditional use permit has one area of notification, a large-scale development has a different area of notification. So we've differentiated that so that people can see that there's a difference, because we get a lot of people that say, well, I live within so many feet and I didn't get notification. Well, that's because that's for a different project than what we're looking at. So I'm going to keep kind of going on down. There's not a lot. There's a lot of new terms. But anyway, so that's the first section, which would be section 11-1 under the old plan, old code. 11-2 was an anti-displacement plan. We removed that. The reason for that is that was passed by a resolution. Resolutions aren't binding. You don't codify resolutions. So it never should have been in there. Doesn't mean it's gone. It just means that it's not codified because we don't codify. The AAC, if we left it in, wouldn't codify it because they don't codify resolutions. Section 11-3, attorneys, engineers, surveys, real estate licensees. This was something that we talked to the Board of Realtors. They came and met, and we talked about this and an issue they had. And basically what this says is every attorney and engineer and surveyor and real estate agent and abstract title company, mortgage and lending institutions have to tell everybody that they talk to about our code. Well, we realize that that's not going to happen. I mean, that's not feasible. It's not practical. There's a vast majority of people don't know. People that do know, sure, but most people don't know. Most attorneys can't tell you what Washington County Code is. And so at their request, we removed this. We weren't enforcing it. It had never been enforced, and it had never been an issue. So that was removed. So then we get to Article 2, the Planning Board reestablishment. There was a planning board. It was taken away, and then it was reestablished. We changed that just to kind of say the establishment, the board is established pursuant to 1417-203 of the Arkansas Code. We put in here that it's both the members of the planning board are also members of the zoning board of adjustment. The Arkansas law is clear on that and how that operates. This is just so that there's a little bit better understanding. The parts that are highlighted in this reddish orange are the changes. I'm happy to look at if anybody has any questions, but we changed the wording a little bit. As you can see here in membership, we added the zoning board of adjustments. One thing that the old code had here, you see duties and functions. If you look right here, 17-1107, Arkansas law is not even codified the same way as it was back when this was passed. So this number right here wouldn't get you anywhere if you were looking. So we went in and we updated those sites so that now you can go and find the law on that. Again, zoning board of adjustments. We changed this to say that the zoning board of adjustments and the county planning board, you all by vote get to set when your meetings are going to be held. Kind of clarify that for anybody. Unfortunately for all of you, compensation hasn't changed in a very, very long time. We'll move on. So next we get to building regulations. We tried to do some updating of this to bring them up to current times. And so here we have a whole section you can see, just like there was, we removed the exemption from the underground facilities. That was another resolution. Portable toilets that we have, we updated this, Sam actually did, to basically say, hey, you got to follow federal law. federal code. There's no option for us. It doesn't change anything. It is what it is. The rest of this is exactly the same. The moving of buildings or occupancy, nothing changed there. There was a form that was hard to follow, if you look. This one's not as bad. There are some that get a lot worse. The formatting got off a long time ago, and so they're hard to follow. We pulled those out, put those in the back so that they weren't listed there. Same thing here, the occupancy permit. I'll be real honest, since we've been here, I think I've only had one issue of somebody moving a house, house. And it was an issue because they got it stuck. And it was an issue because it was there a couple of days and it was not fun to deal with. Actually, we've had two of them. And none of them came and got permits from us. But it is what it is. I think we updated these permit prices, I think, Sam?
Yes, sir.
To bring them up because they were from what they were way back whenever they were set.
70s.
And the violations and all are the same. Procurement of professional services, there's a law that says that the quorum court can pass an ordinance that says they don't have to do formal bidding for the procurement of certain professional services. The quorum court years ago decided to do that for contractors acting as consultants. But again, no change there. Section 4 is the land development area. There was I think this was misspelled. I think it said the Washington County Placing Board or something, so we changed that. Lot size and parcel. This was updated to better coincide with what is the current state law. Is that right, Sam?
Yes, sir.
And so that's all we did was bring this up so that it is exactly as the state code and fits perfectly with what the health department requires. And at any time, if anybody wants to stop and look at the cross-reference of where it was, let me know. I'm happy to do that. I've got them all marked, so I can tell you exactly what section it was. You can go, we can read them word for word if we want to. Again, a lot of stuff that doesn't change. Here under this topography, what we had at the time was, I think it was 10-foot intervals or something. It was real outdated. Technology's gotten so much better, so Sam updated this to allow people to use other things other than the old topography and to make those intervals different on what we.
Yeah, we have LiDAR that's like up to like 1 to 2 inches. So.
Okay.
Yeah. We changed the number of copies. We added that you could just submit one PDF. There's no point in submitting 13 copies anymore. We'll take one PDF. You're gonna get paper. We'll take 6. We'll go from there. We updated the site, as you can see here, back to the other sections. This was the submission, and Sam updated kind of the process that we use, kind of explained it a little bit better as to the plat review committee, who that is, and the process that they utilize. And so it was really just putting language in that better reflected what we are currently doing and have been doing for a while.
And just to clarify, all of this already been discussed with the quorum court for over a year and a half, so.
The yellow, as you can see, I've noticed some Scrivener's errors. I'll go back and fix those. Those should say step 3 instead of step 4. Still the same thing. We added on the preparation and construction, the plans, we've added the administrative officer along with the county road superintendents, and the administrative officer from the de facto administrative officer is our planning director, unless the county judge or the planning director have someone that if we get to the point where we have a full-time somebody that does that other than the planning director, that can happen. So we've just added a couple of people to also be able to approve what's going on, to get everything updated. We added a little part here about you've got to get the Department of Health and the other utilities when you're going to go and change these things. Again, you can see some Scrivener's errors. I will take full responsibility for those and not catching those sooner. Site change, added a PDF. Changed the section here so that it fits. The purpose of this is so that the AAC can then codify it into their sections and headings and all that. Same thing here, same thing on changes of our copies here, sites. Planning board action upon review of the final plat, we added some language to clarify. And the approval will be provided in writing by the administrative officer. I think it said county judge, but in practice, it was always the planning director that sends out a notice to the applicants to say, hey, your project has been approved, you can move forward on what you're doing. So we changed that. I think we added the road superintendent, county judge, as people that can submit, or the signatures. We currently have to get signatures from the county judge, the road superintendent, and the planning director, and so we've updated to reflect that. One thing that we did change, one substantive change is Sam felt like the better group to assess or set fees for planning would be this organization. You guys are more intimately involved with the process and what's going on. The quorum court can change that if they want to, but it would allow the planning board to actually work with the planning department and set those fees as necessary should changes need to be made.
But those were updated since, as part of this codification, correct?
What's that?
The fees have been updated from what was previously.
We have not updated them since, I guess, last time, 2016, 17.
Okay.
Yeah, we're gonna work on this because like everything is changing and
Okay.
we pay a lot, I mean, like towards the work than what we get.
Yeah.
And almost every city is like charging maybe 3-4 times that
Okay.
what we charge, so.
Okay, so, but that's something we'll address.
Absolutely, it's gonna come to you
Sorry,
definitely.
didn't interrupt.
No problem. This here, the existing condition, it was 10-foot contour intervals. We changed it to 1, 2, 5, or 10 due to the new technology. Signature block for the planning administrator officer / planning director. And then we added something, a little detailed plat checklist and signature blocks, just something for people to know where they could go to find that information. It's just a section change, given the new section. This is Sam, can you speak to this update, the plat survey submitted? Oh, this shows that what requires a minor subdivision?
Yes, sir.
Just because there's a lot of questions about that, I think?
Yeah, well, it's just a clarification. It's in our code, like it's already there, but it's not explained. And most people, like the surveyor would know it, but like lots of people, they will go and tell the surveyor, no, that's okay, let's do this. And then when they submit to us, we tell them that, yeah, that we cannot do this we cannot process this as an exemption. It has to go before the planning board. So basically, one of the things that's in our code, it's always like 5 acres. If you're creating more than 5 acre, like 2 lots that at less than 5 acres, it has to be treated as a minor subdivision and come before the planning board for too many reasons. We're connected to like lots of regulations, fire safety, health department. So that's one of them. Let's say if like you have 10 acres and you're gonna split this like 5-5, it's fine. But if you have like 7 acres, you're gonna split this like 5 and 2, that's a minor subdivision. It's basically the same process, but it has to come before you so we can make sure they have all the requirements that matches the septic and all of that, and it needs to be approved and get the signature from the utilities and the health department on that survey before it's being recorded for record. So if someone sells it, at least like, you know, that went through the whole process.
We also added a violation section because there was no violation sections. This had no teeth, and so in order for the planning board to actually, or the planning team, the planning board to actually enforce these rules, you have to have violations, and so some violations were added.
Okay, so let me stop you there, because that's one I get asked quite a bit about as we approve things, who's gonna regulate it moving forward. So this actually has monetary fees for violations, correct?
Correct.
What's code enforcement, whose responsibility is that, is that
The
planning,
sheriff's
is that
office.
sheriff's office? Okay.
That's the
All right.
sheriff's office.
Thank you, I appreciate it.
Who's gonna define what a violation is, or an appeal, or if there's a disagreement?
So the planning department would be the one that would notify the sheriff's office of a violation, and the sheriff's office would then issue a citation. And then if somebody wanted to disagree with that, they take it to court because it's a ticket like anything else, like you would if you were appealing your speeding ticket or something. You would go and it'd be adjudicated by a district judge.
Initiated by the planning.
That's correct.
It's complaint based. It comes to us and then like we go from there. Yes, sir.
Right,
Yes.
the planning department, the executive branch ultimately, the county, I guess you could say the county judge's office, but it all comes originally from the planning department, regardless of what happens. They're the ones that make the determination.
Therein lies the change.
Yeah.
A change?
Right, the county judge can say, I wanna fine you for this.
No, the county judge
Just
can't.
slide with that.
Okay.
Selective enforcement could occur.
Okay. Moving on, we got residential lot. I think Sam updated this to 1 acre because that's what our minimum lot size is.
Yes, sir. Yeah, for a residence, yes, sir.
Let's see. We changed this here. This used to say in the county fire marshal, we don't technically have a full-time county fire marshal like we used to. It used to be housed in the sheriff's office. And so we've turned a lot of those review over to the local fire department because they're the ones that have to look into any of these issues and determine whether or not they can respond or if anything's needed. And so that's something that we kind of lean on the fire departments to.
So it's county judge and the local fire department, that's both, correct?
Right, yes, and the change is, the only change here was this said, and the fire marshal, and we changed it to the local fire department and the administrative officer, the
It's
planning
the only
director.
extras.
Because we don't have a fire marshal,
Judge
correct?
was in the previous one.
Yes. There's a whole lot of road stuff here that was not changed, not touched. I'll skip over it. We added, just for clarification purposes, compliance. There's a lot that come up sometimes. We get questions about the sewer system, so we noted that you have to comply with these ordinances that were already passed, and we included them with this as an appendix so people could find them more easily without having to go to find them. And that was just to help with clarification. We changed this to the Arkansas Health Department. It used to say Washington County. They're no longer county health departments. They're state health departments. I'm not sure what this, so there were several changes that were made on some of these because there was a change by the legislature whereby the legislature has done away with the extraterritorial jurisdiction area of the municipalities. And so we had a lot of language in here that talked about that extraterritorial jurisdiction area, or what a lot of people call the future growth area. So we've had to remove all that because the laws changed. And so we no longer defer to the cities in those areas. The county has been forced to reabsorb all that. So we made some changes here.
When did that go into effect?
That will go into effect on August the 5th.
It was approved April 16th, so it should take like 90 days from that. So I would say about
Well,
the
90
first,
days from
second
the end of the
week.
session. So
Yeah,
anything
first,
that wasn't,
second week.
didn't pass with an emergency clause goes into effect on August the 5th,
Yep.
the new laws. Let's see. We added a provision here, this was in gated communities for keypads that all emergency services have access to those keypads, fire, EMS, along with the sheriff's office. As you can see, some site changes. Time limit for development permittees. I'll let Sam talk about this.
Yeah,
Is more
this has already been there, but it was like scattered like in different places. So you just like compile them and we tried to consolidate everything in one place to tell you if you're doing large scale, you have to finish everything within, and you can always apply for like an extension, and we can get you the administrative or the planning director at the time can give you like 90 days extension back to back. So that will extend it by another half a year, so you can finish up. It's already been there. Nothing has changed. It's been moved from one place to another to make it more consistent.
We updated the hazardous chemicals to comply with the current hazardous chemicals, and basically we just reference what the federal government says the hazardous chemicals are. Prior to this, I don't remember what year exactly, back in the 80s or 90s, they passed, there was a long list, you can't even read it. If you go look at the ordinance, it's so blurry, you can't read what it is, so we just kind of updated this to say, hey, these are federal law says these are hazardous chemicals, to make that a little bit easier. We did change the notice requirements. We are trying to get away from the county planning, having to send the ones that are responsible for sending notices out, and put that onus on the developer or the applicant. The reason for it is ultimately the developer or applicant would pay for those anyways. Maybe, hopefully, a lot of times when they got denied, they wouldn't pay, and we couldn't get in touch with them, they'd get new phone numbers. So what we are proposing is that they be the ones that get this notice out. They're required to send them out in time. They've got to show that they're out in time. They've got to send them the same way, in the same time manner that the county would. The planning department, though, will give them the list of neighbors within each area. So they won't have to go figure that out. We will actually still provide that information. Sam's team will get that to them, and then it'll be on them. They'll be out the expense, and they'll be out the time to get that done, and it's not tying up our planning team.
And that is commonplace for municipalities in this county and for other counties and municipalities. as
Yeah,
well.
we're
And
actually
that's-
the only county in the
that's-
state like that,
yeah.
is still like doing
That's-
that,
that's,
so.
I think, a great change.
And one of the things we're gonna do also, like, we're gonna provide them with the labels, so it's not just like the names or a list.
Yep.
So go ahead, like, print this and stick it, and like, go from there. We're gonna give them also like a format for the neighbor notification, email everything. That's exactly what needs to go out. Just send this, and we're gonna give them a time. You need to give me like a proof that all this went out
Yep.
by this time, so we can have you on the agenda next time. Yep,
Okay, thank you.
absolutely.
We did add some language here. This is all under what Section 4, which is land development. There was a lot of confusion about who the appeals go to. And so we added language that hasn't been in here that makes it very clear that the appeals procedures that are discussed in this section since passage back in 1991, that's when this ordinance that's originated, and I can go back and show you the language. But we wanted to make it clear that for this, it's only in this section. That any appeals of a conditional use permit is dealt with in the conditional use permit section. That all goes to the quorum court. So there had been a lot of confusion because there's this sentence that says the county judge may waive the above appeal requirements, however, the county judge's decision shall be final. Again, that goes back to a 1991 ordinance. And so that people understood that has nothing to do with conditional uses. It has to do with what's listed in here and what was listed in that 1991 ordinance.
Okay.
Here, we're just saying that the zoning board and the administrative officer sign off on the variance like you've just had,
Yeah,
same process that we currently have.
Yeah, the administrator officer basically is the default like position for almost everything we do in the planning department, and we can always like have, it's either like the planning director or like one of the employees. So this is basically the default like position for anyone in the office.
May I ask a clarifying question?
Turn your mic on, would you?
Excuse me, I was gonna say, we can't hear it without your
Yeah,
mic.
I got it.
Yeah.
I got it.
Hear Mr. Mayor.
And I hate to back you up for what you just talked about.
Sure.
But on the county judge portion.
Yeah.
I've received some comments. And so we're saying that actually nothing in that language has changed from what it originally was about the county judge having final say.
Nope. And I
Oh,
will,
no, did I misunderstand?
I mean, I can, if you want to see the original ordinance, I'm happy to pull it
No,
up for
no.
you.
I'm, just explain that again, if you don't mind.
Some of the first land regulations that came out was passed in 1991. It was 1980-50 was the original one.
And just for clarification, this is on land use.
This is on
only.
land
This is
use.
Yeah,
not
land
on
use
conditional
only.
Not on
use
conditional
permits.
use.
Yes.
Make sure, because
Okay.
I've
Okay.
gotten a lot of those same questions.
Yeah.
And that's very
That-
specific
that's
to
why I
land
wanted to
use
clarify.
only,
Yeah.
That's
not
correct.
conditional use permits or any other action.
Yeah.
So I
So
didn't
in-
mean to interrupt you again.
Ordinance 1991-9, which was filed April 12th of 1991, is where that language originally comes from. And that's the exact language that was used in that ordinance. It's kind of hard to read because it's old. Let's see if I can find it for you real quick. Go back and look here, see. Bear with me a second. Get into, here we go. Enforcement inspection penalties down in Article 8 of this particular one. 8. Let me go to 8. There's also a lot of old drawings that we had been using too. We've updated those in the new one. But 8.02.3 in that ordinance says the county judge may waive the above appeal requirements. However, the county judge's decision shall be final. In 1989, there was an ordinance updating that And that remained the same. And those are the only time that those 1980, 1991, and 1993, maybe it's 93, maybe I'm getting it wrong. Anyways, there's 3 ordinances there. And so that's the original language, nothing's changed. Our goal here was not to make any substantive changes. We were really trying to update this to get it up and get exactly what we had, so that we at least have something on the books that we can then start going in, and the quorum court or the planning board can go in and start updating, but the people have something they can go find in a codified code.
And
So-
again, it didn't have anything to do with conditional use permits.
Had nothing to do with,
The
in
language was added
1980,
was specifically to state this is for land use only,
Yes, sir.
conditional use goes back to the.
when those
ordinance.
3 ordinances
Okay.
were passed, there were no conditional use permits. Conditional use permitting did not come about until 2006.
Yeah, November.
Okay, thank you for that
You're welcome.
clarification. Yeah.
Let's see, is there anything else? We put a section here about, the county, we won't accept everything until the final plat's been approved, so that applicants know that, that you have to hit all these barriers before we will accept the final plat. We did change the violation amount. It's all we've changed, is the violation amount. And we put a section here that says the sheriff's office shall issue citations. And the quorum court authorizes the prosecution, recovery, and collection of these fines. We've had a hard time with, there have been penalties. There's a penalty that's already in, but it doesn't say how people get that penalty, who writes a ticket. We can't write tickets. The county judge's office, we don't have an enforcement office, and so the only option we have was for the sheriff's office. So we wanted to clarify that, that's the desire of the quorum court, is that people that are violating our rules and our laws, that it's just like a city code violation, the police come out, or code enforcement, we just don't have that, so it all defaults back to the sheriff's office. Then we get into road base and roadways, and as you can see, there's no change whatsoever in any of this. This is exactly as it has been written, and as it currently stands. Storm and drainage requirements, again, I don't think we made any changes there. Inspections,
Yeah, that's industry standard, so we did not change anything, so.
I really don't think we get into any changes until we get to the zoning. And so this changed, and it was changed back, and so some of these changes are what the quorum court has put in. It defines a conditional use permit, and these conditions of approval, these are things that the quorum court added back into this not too long ago, a few months ago. Some language they added back, so we added in. The rest of it is pretty much all the same. This section, some things that the quorum court changed to kind of clarify better the process that was being used or is currently in place. This talks about the, extending the planning board's got to approve it. You have to be in conformance with your site plan. Talks a little bit about the development plans run with the property. I mean, it's really just a clarification on what we currently have, so that
It's
people have a
language
little
that
bit.
like been taken from different places into one section.
Yeah. Time limits, appeals, variances. Notification, we made, hey, this is gonna be just like what it says the notification is. Again, fees, planning board, and then we'll list the fees will be housed at the planning department. We added that, this is already in, we moved it up to here. It basically says that if this board disapproves or denies the application, the planning director, within 15 days of that, will let the applicant know why the planning board did what they did.
Yeah, normally we do it the next day, so.
Yeah, I don't think there'll be any issues there. Again, changed from the county providing these notices of appeal to the applicant providing the notices of the appeal. We added that the people can, a denial, you can reapply if you amend your permit or a new project scope, you can reapply. So that you don't have people that get denied and then turn around and just reapply the same thing and keep doing the exact same thing. Flood damage, we had to update our flood prevention code. It's been adopted by ordinance 2024-3. That was required by the federal government. All of this that you see in here is the language word for word that you get from that ordinance that's already been passed.
Yeah, and that was like the red stuff that was sent by FEMA to me, and this was like, that has to be there.
So a lot of it was the same from the previous flood ordinance that we had. So then we get down to the placement of the antennas, and I don't
It's
believe we
exactly the
have
same.
any changes there. Let's see. Yep, and that's it. And then all we have under that, we have the appendixes that we talked about, which some were up in the ordinance. We moved them a little bit easier. We also, as you can see, have some really nice drawings where we had some really bad drawings. We've updated those. And so that's it. That's what we're doing. Like I said, with the exception of a few changes, minor changes, it is essentially what we currently have, just gives us the ability to have that codified so that we can have that out for people to look at.